Toyese Adenipekun joins us now. He's a legal practitioner. Thank you for coming on this morning.
It's my pleasure.
Well, focusing on this, so much has been said and will be said, but the thing is, they hope so much will also be done so as to not find ourselves in this kind of ridiculous situation as some people described it yesterday. From your perspective on the goings on, particularly with this judgment, were you also surprised, as some people are?
Yes, I am. I'm very much surprised.
Why?
Well, given the facts of the case, given how much is involved, 32 billion naira or more, you would have expected that if the judgment was going to go in the way of a fine, then it would be something substantial. If it was going to go by way of a term of imprisonment, it would have been substantial enough to bring about the deterrence value of the criminal justice system, which is at the bottom of prosecuting offenses.
Okay, what about when you take into consideration that it's a plea bargain, judicial discretion can be exercised by the judge, and remember, the maximum sentence is 2 years, and so if there's a plea bargain, we understand you can't serve maximum sentence. So,
yes, I've also put that into consideration, but look at it from another angle. There is a penal code which was, used. The prosecution actually took place with the application of the penal code, which applied 2 years. But the same offense is provided for by the EFCC Act, which stipulates a penalty of between 15 and 25 years.
Which year's act is that? Because
The EFCC Act.
Yes.
the
current
recent
or
one,
the
the most
amended?
2004.
Even the 2004 and even the amended, version stipulates between 15 and 25. And one would have expected that the prosecutors would have brought the accused persons to court. They would have been charged
Under the
pursuant
Act.
to the EFCC Act stipulating between 15 and 24. Now, if in the discretion of the judge, he turns a verdict that, sends the accused persons to a jail term of, say, 15, that would have been understandable. Now, plea bargaining, yes, plea bargaining can take place. The whole essence of plea bargaining, is to ensure that there's speedy dispensation of justice, rather than have an accused person come to court, waste time after pleading not guilty in the first instance.
But
And then you have
do we
to
have
bring-
that in any of our laws? I mean, it's believed that it's alien and was borrowed, and there's no regulation for it in our laws.
Interestingly, there are provisions in our law for plea bargaining. If you look through the EFCC Act, the Criminal Procedure Act, there are provisions. Even the Lagos State Criminal Justice Administration Law of 2007, Section 70 of the Lagos State Law provides for that. Section 180 of the Criminal Procedure Act, a very old legislation, provides for that. If you may permit me to read Section
sure,
180 of the Criminal Procedure Act, CPA, this is what it says. When more charges than one are made against a person, and a conviction has been had on one or more of them, the prosecutor may, with the consent of the court, withdraw the remaining charge or charges, or the court, of its own motion, may, stay the trial of such charge or charges. That's what you have in Section 180, subsection 1 of the Criminal Procedure Act. Now subsection 2 of Section 180 says, such withdrawal, that is, of the other charges, such withdrawal shall have the effect of an acquittal on such charge or charges, unless the conviction which has been had is set aside, in which case, subject to any order of court setting aside such conviction, the court before which the withdrawal was made may, on the request of the prosecutor, proceed upon the charge or charges so withdrawn. So, in essence, you have 10 counts. Now, the charge or charges are plea bargained. You may withdraw 8, then you leave 2, which will earn the accused persons or person minimum sentence. What becomes of the 8 withdrawn? It's as if he has been acquitted of any wrongdoing concerning the 8. Now you look at the 2. Usually those 2 charges that are plea bargained usually carry light sentences. And that's simply what Section 180 here is saying. So just 1 will be sufficient. Even if you have 1 charge left, that will still be sufficient to procure his prosecution to the end. And interestingly, even the EFCC, Act in Section 13, subsection 2, if you consider both, paragraphs B and D, it not only gives the prosecution, the powers to prosecute offenses, it also gives discretionary powers with regard to asset recovery.
The point is, if you allow me comment here, Toyese, is this, do you smell a conspiracy here? Because if truly we have the EFCC Act that stipulates a maximum or minimum 15 and maximum of 25, and we'll still go with the penal code, knowing full well that this was a huge case and a test case for us as a nation to show this fight against corruption. Do you smell some kind of conspiracy here in all of this?
Well, without going into the politics of it, let me just deal with the facts of the matter and limit myself to principles of law and, court procedures. Conspiracy, well, it is hard to prove. But one thing is clear. Everybody has suspicion that something wrong took place somewhere. I mean, if you look at the language of the Criminal Procedure Act here, there has to be consent of the judge. Now let's go back to courtroom procedure. Let's deal with 10 charges, as I mentioned earlier, for the purpose of discussion. Now you have 10 reduced to 2. Likely you would have brought a motion seeking to amend the charges. The charges of the information earlier brought to court would necessarily be amended. Now, in the process of bringing a motion seeking amendment of the charges, your affidavit must contain facts that will convince the judge that indeed, yes, this amendment should be allowed. I wonder what the affidavit contained. I wonder what the prosecution had to tell the court before the court was convinced to allow, the initial charges to be reduced to what we finally had.